If there is time at the end, we did this last week. It was really ended up being really helpful. We're going to do a breakout session, and so you'll be put in different groups, and we can kind of discuss some of these issues. I will just have a caveat. We will see how the question and answer section goes. I think there's going to be a lot of information here, and I imagine that may take or be kind of as a group maybe more interesting today to do that because we have a great panel that can answer a lot of those questions. So I think at this point, that is what we will do. Again, just want to thank each of you guys for coming. Hope that you're all safe and doing well, your families. And I do think it's worth mentioning if you have family and friends that are, working on the front lines in healthcare, we appreciate you supporting them, and then obviously all that they're doing, and we do want to be mindful of them while we discuss today. So at this point, I will turn it over to Jason to introduce the panel and give us a better overview of the discussion today.
Great, Sean. Thank you very much for the introduction, and we want to thank the Family-Owned Business Alliance for allowing Parsons, Behle, and Latimer to be a part of today's discussion and to provide the content and information for today's webinar. We've got a lot of content to cover today, so my introduction is going to be relatively brief because we have a very substantive presentation with information that is relevant to all of our attendees and your respective businesses. My name is Jason Castro. I'm the Director of Business Development for the law firm of Parsons, Behle, and Latimer. And today's presentation is really going to zero in on 3 different acts. We're going to use a lot of acronyms today. The first act is the Coronavirus Aid, Relief, and Economic Securities Act, which is also referred to as the CARES Act, that was passed and signed by the president a week ago, or on Friday, I believe it was the 27th. We're also going to touch on updates to the Families First Coronavirus Response Act, which was signed into law on March 18th. And then the last element that we're going to cover today is the WARN Act, which was passed in the late 80s. I'm going to share my slides or advance the slides now. And for some reason, this is freezing up. There we go. To transition to our webinar format today, we'd ask that all of you keep your lines muted. We will be taking questions throughout the webinar today by using the chat function to submit questions. Mark Wagner from our team will be facilitating those questions. Today's webinar is being recorded and will be shared with you at the conclusion of today's call. And we will also provide our slide deck to all of the participants today. Our presenters include Ross Keogh, Mark Wagner, Sean Monson, Susan Mott-Schiedler, and Christina Jepson. And before I turn the time over to our presenters, I need to provide you with this disclaimer. Given that things are rapidly changing, we and our team is working extremely hard to keep up with all that is happening. This webinar today is based on available information as of April 2nd, but everyone must understand that this webinar is not a substitute for legal advice. If there are questions about the information contained in this presentation and how it applies to your business, then you should consult with your legal counsel. This presentation is not intended and will not serve as a substitute for legal counsel on these issues. Given the complexity and rapidly changing landscape, you must consult with your legal counsel on all of these issues. So we have to do that. We want to make sure that you understand that this is general information and not legal advice. Okay, so now the exciting part. We've got, like I said, a very substantive presentation that is going to cover the 3 acts that I mentioned at the beginning of my introduction. I'm now going to turn the time over to Ross Keogh, who's going to talk about the CARES Act and loan forgiveness. Ross?
Thank you, Jason. And thank you to Sean and the entire organization for having us here at Parsons Behle to provide this webinar. Obviously, we are dealing with an extraordinary moment in world history. And I hope that any of the information that we provide today will be helpful for you that are facing these extremely challenging and dynamic decisions you need to make in your business. We got jobless numbers today from last week. It appears that probably sometime today, about 10% of the American workforce will have been displaced. And the good news, which we know, is that Congress did respond last Friday that was the CARES Act. And I'm going to spend talking about some of the key in the CARES Act that I think may be of interest and assistance for you in your ability to respond to the ongoing pandemic. So the CARES Act has sort of four legs to stabilize the United States economy, which supports about $2.2 trillion in spending. The first leg of that table is direct taxpayer subsidies of about $1,200 in payments and additional unemployment support. We're not going to be discussing that in today's webinar. The second leg in the table, which I'm going to discuss very briefly, is a $500 billion Treasury program, which has direct intervention funds organized. Very similar to the TARP program in 2008. The third leg of the table, which I suspect you are starting to become familiar with, is the $309 billion, what is known as the Paycheck Protection Program, that is going to be administered by the Small Business Association through their existing 7A loan framework. And then the final provision, which I will talk in some detail about and highlight a couple very critical provisions, are various tax changes that allow for small businesses to sort of use the tax code as a source of liquidity going forward. So with respect to the $349 billion PPP or Paycheck Protection Program, this program was passed on last Friday, and applications will begin to be accepted by local SBA lenders beginning tomorrow. You can find specific details about the application on both the SBA website and Treasury's website. And if you're at all interested in this program, and I think virtually every single business on this call needs to be evaluating this program, I strongly suggest starting to coordinate with your lender about eligibility and how it's going to work. So I'm happy to answer any nuanced questions about the program over the chat as we go forward, and Mark can direct those. But all I'm going to do here in this short time is just give you a very high level of the program. It's available for any business that is less than 500 employees that was operating before February 15th. We have significantly expanded eligibility. And I want to really highlight this point because a lot of my clients, having sort of worked through the analysis themselves, are now turning to talk about the rest of their supply chain, making sure that their independent contractors or their suppliers or distributors are also taking advantage of this to further stabilize the entire business network. There's no personal guarantee required for the loan. We have extensive deferral and forgiveness benefits, which I'll discuss on the following slide. Interest is going to be capped at 4%. There's some confusion about what actual interest rates are going to be under these loans, which we expect to get clarified hopefully today. And there's a $10 million cap on the amount that you can borrow. Your potential loan amount is a function of your average monthly payroll multiplied by 2.5. So if you have 10 people and you pay them $2,500 per month, your amount will be $25,000. If you have any employees that have in excess of $100,000, you need to cap their wage at $100,000, and you get to add in associated other payroll expenses like healthcare costs, retirement, and so forth. The big carrot with the PPP loan is the potential to get the loan forgiven. That only occurs based on what you can spend on that loan in the 8 weeks after the date of origination. All expenses associated with your payroll costs, interest on covered mortgage obligations, rent obligations, and utilities are eligible for forgiveness. However, if you've had reductions in your workforce as compared to one of two benchmarks in Q1 of 2020 or Q1 and Q2 of 2019, then the amount of loan forgiveness is going to be reduced proportionally. There's also a further reduction if you take reduce salaries of workers by more than 25%, except for those highly compensated individuals that make more than $100,000. I'm seeing a question from Jeff Garrett, and yes, it is average FTEs that are used for the calculation in the proportional reduction of forgiveness. Next slide, John. That's the PPP loan. The SBA, one of the other benefits of the CARES Act, and this is for those of you that have existing SBA loans, there's now $17 billion that has been allocated to allow for deferral and payments on your behalf. This excludes idle loans, but includes most existing 7BA facilities. If you haven't reached out to your lender with respect to this provision, it's a huge opportunity, and we encourage you to do so. I'm going to now turn to some of the critical payroll changes and tax subsidies that are in the bill. And the first one I want to highlight, which is a payroll tax credit that is available. This is known as the ERC credit, and it is important to know that this credit is in lieu of the PPP loan. So businesses that are looking at their liquidity options should evaluate, of these two options, which makes the most sense, the PPP loan or this payroll tax credit. It's available in two circumstances. If your organization has suffered a partial or full shutdown by a shutdown order, you're eligible for this ERC credit. What does that mean? We think it means, for instance, if you're a movie theater, right? In most states in the United States, those have been shut down. It's a little less clear if you're a restaurant, or maybe you're still doing takeout if you've been subject to a shutdown. The other circumstance that makes this credit available is if you have had a decline in your gross receipts in a quarter by more than 50% as compared to the same quarter last year. It's unlikely that very many businesses will meet this test in Q1, but Q2, it could very well be likely. And that continues not until you have gross receipts exceed 80% in a quarter that you can take the credit. Now, the credit is limited to $10,000 in applicable wages per employee, and it's at 50% of those wages for a $5,000 credit. There's another distinction based on if you have fewer than 100 employees or more than 100 employees. If you have fewer than 100 employees, all wages that are paid either during a shutdown order or during a quarter with those gross receipts decline starting after March 12th are eligible for the credit. If you have more than 100 employees, it's only the wages that you pay to employees that are effectively idle, still receiving some sort of subsidy from you. It can even be just limited to health insurance, but they're not working or providing services to the employer. So the credit is immediately refundable. Treasury issued the draft form yesterday that allows for businesses to submit and claim the credit ahead of their payroll obligations if they might qualify. And critically, healthcare expenses are qualified wages, and this is also available to nonprofits. Again, it's limited to $5,000 per employee. I now want to highlight two provisions that provide a lot of opportunity to help employees in other ways. The first is included in the CARES Act. This is a tax-free payment on student loans. It allows employers to make payments on an employee's student loan, and that is tax-free to the employee. So a lot of strategy here about a potential reduction in an employee's salary, but yet providing them a subsidy in the form of a student loan payment. The other analogous provision, which was already contained in the tax code, are disaster relief payments under Section 139. These were triggered with the national emergency declared by the President on March 13th, 2020. This is a provision that originated in September 11th, and where we had some issues with compensation associated with funerals. It is extraordinarily broad, and you can pay any individual any reasonable expenses associated with responding to the pandemic, and those will be excluded from the individual's gross income, and potentially, depending on if the expenses are a trade or business expense, deductible for the employer. This might include costs to set up and maintain a home office, medical expenses, housing, increased childcare expenses, and costs of maintaining social distancing. I want to just highlight a few other final provisions and then turn over my time. RMDs from IRAs are now suspended for 2020. Net operating losses can now be carried back 5 years, starting in 2018. In the 2018 tax year, you can also amend your return to immediately depreciate improvements to the interior portions of commercial buildings. The employer side of Social Security taxes can now be delayed 50% until December 31st, 2021, and 50% to December 31st, 2022. It's important to note that that provision, though, is in lieu of the SBA loan PPP forgiveness provision. And finally, the business interest deduction cap has been increased to 50%. Thank you.
Thank you very much, Ross. We're now going to turn the time over to Mark Wagner, who's going to talk about unemployment issues under the CARES Act. Mark?
Thank you, Jason. And just briefly, because I just responded to a question on the chat, I want to make sure I'm correct on this, Ross.
Hey, Mark, this is Jason. Sorry for the interruption. We're having a difficult time hearing you. Could you lean into your mic just a little bit more, please?
Yep. Is this better?
Yes.
Okay, great. Just before I started, I wanted to check with Ross. I responded to a question on the chat. Just have him double check my answer, but my understanding is that hourly non-full-time employees are included in the payroll provisions, credit provisions for the Triple P program. Is that correct, Ross? You're on.
Yes. Yes, Mark.
All right, just wanted to be sure.
Any employee compensation will be included in the ERC program.
Great, thank you. I really appreciate it. So the unemployment provisions of the CARES Act, these are significant provisions, and to some extent, you know, to the extent you can get relief under the Triple P type of program that Ross overviewed, I think that, you know, would be, of course, preferable to having to lay people off. However, if that does happen, the CARES Act does contemplate some pretty dramatically expanded unemployment benefits. And basically, it contemplates doing this through federal-state agreements that are entered into by each state and the federal government to funnel assistance from the feds to the individuals through existing state unemployment compensation programs. So one key takeaway from that, though, is that benefits aren't under these expanded benefits are not going to begin until after states actually enter into these agreements. As of yesterday, when I checked into this, my understanding is that Utah is in the midst of the application process, trying to get together a federal state agreement. I should actually have a call later today where I should find out a little bit more detail about where we're currently at. But the agreements under the CARES Act can provide for expanded benefits in three distinct kind of ways. First of all, they can provide for federal funding for unemployment compensation benefits for self-employed workers who are adversely affected by this. And typically, self-employed individuals are not covered under state workers' unemployment insurance schemes. If I've said workers' comp before, I'm wondering right now if I have done that. But of course, I mean unemployment compensation. But in Utah, that's also the case that individuals, self-employed individuals, have not been covered or not covered under the regimen. Now, it's a little unclear whether or not that will require a statutory change in Utah. Utah has some of its restrictions written into its act, and it's not clear that the Department of Workforce Services can enter into agreements contrary to what the statute says. But I've also been speaking with some legislative, members of our legislature, and they assure me that they are looking at meeting in the next couple of weeks, hopefully, to assess the situation and take action necessary. Under the CARES Act, it expands traditional unemployment benefits. It can allow for a waiver of the 1-week waiting period. Again, in Utah, that's written into the statute, so that will require legislative action. But one of the most significant benefits under the expanded program is this additional federal funding that's up to an additional $600 per individual per week, and that's on top of what they would otherwise be entitled to under the state program. So it is possible, because these are not prorated. It's a solid 600. So if someone's unemployment benefit amount as computed by the state would normally be, say, $400, they will get to $600 on top of that per week. If it's $580, which is the current maximum in Utah, then they would get the additional $600 on top of that. Again, one important thing is this is going to start flowing until an agreement is in place between the federal government and the state. And these benefits expire on July 31st of 2020. That also provides for an additional 13 weeks of unemployment compensation benefits at the applicable state levels once the maximum amount allowed under state law is expanded or expended. That's up through December 31st of this year. And then third is that it provides an opportunity for states to enter into an agreement with the feds to allow funding for what are called short-time compensation or short-time compensation programs. Utah currently does not have one of those, and depending on the details or the type of program, that also might require legislative action. But essentially, these programs in states that there's a slight majority of the states in the United States that have these, but they allow an alternative to laying off individuals and allow for an agreement usually entered into between an employer and the Department of Workforce Services in Utah, if we had one, or have one, if we get one, and that will allow employers to reduce hours among certain workers and for those workers to receive enhanced unemployment benefits to help make up for the reduction in hours. So with that, I know that was super brief, but I'll turn this over to Sean Monson.
Great, thanks a lot, Mark. We appreciate your insights, and Sean, we'll turn the time over to you to discuss FMLA amendments.
All right, thanks, Jason. If anyone can't hear me, if I get the sketchy audio, please send a text message or use the chat function, and I will fix that and try to move closer to the mic. So what I'm going to talk about real quickly is the Families First Coronavirus Response Act, and that act essentially has two components. There's one component which is amendments to the existing FMLA, and there's another component that creates a new sick leave benefit, and Susan Machiter is going to talk more about that. With regard to the FMLA amendments, and the two statutes kind of work together, particularly with regard to one type of leave, right? The COVID-19 or the COVID-19 FMLA leave, that's what I call it, or the emergency FMLA leave that the Response Act created. Essentially, it amends the FMLA to increase eligibility requirements by expanding the scope of coverage of employers and expanding the scope of employees who can apply for it. So the first way that it does that is that any employer who employs fewer than 500 employees is covered by the Act. Now, there's an exemption that we'll talk about a little bit later, but that's kind of the baseline of coverage by employers, that any employer who has employs fewer than 500 employees is covered by the Act. Employees who are eligible are employees who have worked for 30 days. That's obviously, as you can tell from the slide, I won't necessarily go detail for detail comparison of the slide regarding the regular FMLA because we're short on time, but that's obviously a significantly different eligibility requirement and standard. There's an exemption for employees who are healthcare providers and first responders. So what is the trigger for the employee being able to get leave is if the employee has to stay home to take care of a child because that child's school has been closed, the child's daycare provider is no longer available, or the daycare center that the child is going to has closed. That's the circumstance under which the employee can get this type of leave. And essentially, the school has been closed, or the daycare has been closed because of COVID-19. All right, next slide. Here's the real big concern that most employers have had and that we've been talking with folks about. Under the regular FMLA, there are up to 12 weeks of unpaid leave. So under the regular FMLA, you get leave to take care of yourself if you have a serious health condition, or if you have a family member that has a serious health condition, or for the birth or adoption of a child. In those circumstances, you get up to 12 weeks of unpaid leave. This statute changes that with regard to special leave of taking care for a child whose school has been closed, or whose daycare has been closed, or daycare provider is no longer available. What the employee gets is 10 days of unpaid leave. After that, they get up to from day 11 to the end of 12, potentially 12 weeks if the leave if the leave is needed for that long. They get 2/3 of their regular rate of pay during that period. It's calculated on the average hours that the employee would have worked. If those are variable, then it's calculated based on an average of 6 months. It's capped at $200 a day or $10,000 in the aggregate. So that is a significant potential hurdle and financial hardship to employers, particularly small employers. So there, as I mentioned earlier, there is an exemption that employers who have fewer than 50 employees are potentially eligible to essentially avoid having to pay for these leave requirements and avoid having to provide for this leave if an employee asks. And we've been waiting for guidance from the Department of Labor about how that exemption would work. And we finally have gotten some guidance. The one thing that we do know, well, there's a few things we do know. The first thing is that it's not something that you apply to the Department of Labor to get an exemption. It's a determination that the employer makes on their own about whether providing these leave benefits, and again, I'm just talking about the benefits of allowing an employee to not come to work because they have to take care of a child whose school has been closed or whose daycare provider is no longer available because of COVID-19. And the exemption, the employer has to essentially determine that providing the leave would cause expenses and costs to exceed available revenue if they provided the leave, or that it would cause a hardship on the employer because of this employee's specialized skills or knowledge of the business, or if providing the leave would prevent the employer from being able to find employees who can cover the shift and operate at minimum capacity. So again, it's not something that you apply to the Department of Labor for a certification that you're exempt. It's a determination that an officer of the company has to make that providing leave, again, I want to be very clear because Susan's going to talk about a whole bunch of additional leave rights for sick leave. This exemption does not apply to those. The sick leave benefits that Susan's going to talk about apply regardless. If you have one employee, those benefits apply. But the benefit that you can potentially not have to provide is this benefit of giving an employee leave because their child's school has been closed or the daycare has been closed. And it's a determination, again, that the employer has to make. There's just a couple of things, and then I'll wrap up because, again, I know that we are short on time. A couple of things that I wanted to mention that we're getting a lot of questions about. What about intermittent leave? Intermittent leave under the regular FMLA is something that employers are generally required to allow. For this type of leave, for the COVID-19 FMLA leave, the employer has to agree to it. It's not a requirement. There has to be a dialogue between the employee and the employer, and they have to agree to it. Now, most employers are probably going to want to agree to it because particularly if an employee is teleworking, they still want the employee, if they have work for that employee to do, they want the employee to be able to provide the work and kind of balance the need to take care of the child and providing services at the employer. but it is not a requirement that the employer provide and allow the employee to take intermittent leave. It's highly encouraged. The regulations and the guidance from the Department of Labor say that intermittent leave is encouraged, but it is not required. A couple other points. The threshold for the statute, again, is 500 employees. That threshold is determined at the time that the employee requests the leave. So if right now you have 515 employees, then you are not covered by the Act. But if over time you have to reduce your workforce and you get down to having 475 employees, and that happens maybe in June, and at that point an employee requests the leave rights, then you're covered by the Act. So again, the employee count is not as of the date when the law went into effect, which was yesterday, but it's at the time that the employee requests the leave. So those are some of the common questions that I get, and I just wanted to touch base on those. And thanks for your time, and thanks for letting us join you today.
Hey, thanks a lot, Sean. We're now going to turn the time over to Susan Mottschiedler, who's going to talk about sick leave under the Response Act. Susan?
Yeah, thanks, Jason. So sick leave under the Response Act is a little bit more simple than the FMLA COVID-19 leave, just because it doesn't alter an existing statutory scheme that many people have not been subject to until this law came along. It's a brand new benefit. Everyone gets it. The entitlement began yesterday. It ends December 31st. It applies to employers with 50 or fewer employees. I think that's all of y'all. Employers, like Sean mentioned, employers with fewer than 50 employees can deny an employee paid sick leave under certain circumstances. Like Sean said, as to the 500, the 50 employees is counted at the time that it's requested. So for those of you that waver around 50, if you terminate people during this time, or if people quit, you might dip below the 50 number and be able to deny leave for reasons that if you are slightly above, if you're 51, 52, you would not be able to. And so the three circumstances under which it can be denied is cost of leave exceeds the available business revenue, and it would cause the small employer to cease operating at minimal capacity. The absence of the employee poses a substantial risk to the financial health or operational capacity because of the employee's specialized skills, knowledge, that sort of thing. Or the small employer can't find enough other workers who are able, willing, and qualified to perform the labor or services needed. Now, for sick leave, it's a 2-week period, so the third one would probably be kind of hard to hit. But in terms of the cost of leave exceeds the available business revenue, something that you should take into consideration at this time is that there are tax credits available that are going to cover this paid leave. So next slide. So just take that into consideration when you're trying to make this argument. As I noted at the end, there are documentation requirements that you should take seriously, particularly when denying somebody the sick leave request. For-profits and nonprofits are both considered employers under the Response Act. Like FMLA, it excludes healthcare providers. The DOL did not go into greater depth and detail what qualified as emergency responders, but they did leave a carve out for the highest official in the state to identify additional categories of exempted emergency responders. And there's also a provision allowing healthcare providers to opt out if the secretary didn't provide that opt-out provision in the regulations. Okay, next slide, thanks. So in terms of employee eligibility, both full and part-time employees are eligible, and this is whether or not those part-time individuals already have benefits or not. So this is a brand new benefit, everyone gets it. It applies if they are unable to work, including telework, because they're in a federal, state, or local quarantine related to COVID-19. They've been advised by a healthcare provider to self-quarantine, or they are experiencing symptoms of COVID-19. And so as to the last two provisions, experiencing symptoms of COVID-19, so you have someone who has a dry cough, a fever, extreme fatigue, they can get it, but also the healthcare provider suggestion to self-quarantine can't be that person's own feeling that they may have had some contact with someone who has COVID-19 or may have COVID-19, and they feel themselves that they should quarantine. They actually have to get a doctor's recommendation for that. If they're experiencing the symptoms, they don't. So next slide. Also, somebody who is caring for an individual who is subject to such a quarantine or has been advised by a healthcare provider to quarantine or is sick, they are caring for the employee's child if that child's school or care has been closed due to COVID-19 concerns. And then there's kind of a catch-all provision that are experiencing any other substantially similar condition specified by HHS. So there's another provision that HHS, as this develops, and potentially I think other health conditions could come to light that are related to COVID-19 that are outside the purview of what we consider now COVID-19 issues, they might be allowed to take sick leave for those reasons as well. Next slide. So there is no COVID sick leave under these circumstances. There's been a little bit of confusion, and the DOL has clarified that if the business is closed voluntarily, so there's no work, sick leave is not a benefit that employees are entitled to. If the business is closed by a government, so there was a lot of question about whether shelter-in-place orders qualified as a quarantine under the Act, and it's not, it doesn't. So if your business is closed by a Shelter-in-Place Act or a less restrictive order governing restaurants, nail and hair salons, that sort of thing, employees are not entitled to that benefit under the Response Act. And likewise, if work's not otherwise available because the employee is furloughed, laid off, terminated, etc., you don't have to let them take the sick leave before doing that. Okay, next slide. The hours, so the benefit amount will vary on two things. One, whether they're full or part-time, and then two, the reason that they're taking the leave. So full-time employees are entitled to up to 80 hours of pay. If a full-time employee works, let's say 50 hours in a week, basically you could give them 50 hours in the first week, but they only get 30 in the second week of sick leave. Part-time employees are entitled to the average number of hours that they've worked over a 2-week period. It's for employees that work variable schedules, it's based on a 6-month average. And if the employee has not been with the employer for 6 months, so as you recall, if you've been with the employee for 1 day, so if they started March 31st, they get this benefit today. It's based on what the contract says or what the stated number of hours upon hire were. Next slide. For employees who are themselves sick and are quarantined, those guys get 100% of their regular pay. So for full-time person, up to 80 hours, and it's capped at $511 a day or $5,100 in the aggregate. And just to put a little bit a better face on this, that's based on Social Security wage base of $132,900 salary. So that's a decently high earning rate to cap out at that amount. Then employees who are caring for another qualified person get 2/3 of their regular pay, and is capped at $200 a day. Next slide. And then I doubt any of you qualify for this, but there's a multi-employer bargaining agreement provision on how you split up the sick time payments to your employees under those agreements. Next slide. So the miscellaneous provisions. As employers, you can't require that your employees use any other paid leave options that they have prior to exhausting this if it's a qualifying reason under the sick leave. Employees that are seeking sick time benefits, whether they're sick, remember, whether they're quarantined, or whether they're caring for a child, don't need to find a replacement to cover those missed hours. It can be taken intermittently, only for childcare reasons. So if you think about the reason that part of the reason for Sick Leave Act is to keep COVID-19 out of the business, it doesn't make much sense for people to come in if they're in quarantine. But if they are just caring for a child, then they can split up with different caregivers and take it intermittently if the employer agrees to. Sick leave doesn't roll over, doesn't last beyond the end of the year, and you also have to post a poster with all of your other workers' comp posters and FLSA posters about sick leave entitlement. Okay, next slide. There are penalties for not complying with it. They're Fair Labor Standards Act penalties. So the same thing if you've messed up somebody's pay, same types of penalties. There is going to be a 30-day enforcement grace period. And the DOL wants to offer guidance during this time period instead of turning its attention to enforcement. And then there's a documentation requirement. And so the employer should look at this for two ways. One is if you're going to get the tax credit, you need documentation. And two, you need to keep documentation about why you denied or why it was granted. So you want to keep the documentation regarding the reasons for leave, whether it was granted or denied, any documentation that the employee provided to you about doctor's notes, that sort of thing. And then there is specific guidance from the DOL that you must document oral conversations. And I think that that's important because there is a lessening of doctor's notes provisions, and the requirement to get a doctor's note has been softened because doctors are busy and they don't have time to be writing notes. So I think that those oral conversation notes will count for documentation. Okay, next slide. So in terms of the next portion of this is, I'll cover it quickly because I'm almost out of time, are about the tax credits. So the way that employers cover these costs are through a tax credit, and it's basically employers who provide these, the paid leave, can short their payroll taxes. It's immediate. And so the $200 credit for paid sick leave for an employee, $500, I'm sorry, $200 for FMLA and paid sick leave. Next slide. You take it as a tax credit and against Social Security and Medicare withholdings. Public employees don't, or public employers are not eligible for that tax credit. I don't think that that's any of you guys. You can also deduct qualified health care plans or health plan expenses. Next slide. So you offset both your side of Social Security and Medicare as well as the employer side of Social Security and Medicare, and federal tax withholdings on the employee side. You can request accelerated payment because these credits are refundable. So if your payroll tax is not enough to cover it, you can actually get those refunded. Okay, and that's all. Thank you very much. I'll turn it back to you, Jason.
Thanks a lot, Susan. So we've heard about the CARES Act. We've heard about the Response Act. The final segment of our presentation today will cover the WARN Act, and Christina Jepson will be leading this discussion. Christina?
Thank you. So normally in this part of the presentation, I talk quite a bit about the WARN Act, but the WARN Act mostly applies to large companies and large reductions. And looking at this group of employers that we're talking to today, it looks like most of you are smaller than that. So I'm going to talk a little bit more about some other issues you might want to consider if you're doing terminations, furloughs, layoffs, and then I'll cover the WARN Act a little bit at the end. So first of all, I just wanted to mention that the part that Sean and Susan just went over in terms of sick leave and FMLA leave, the new COVID leaves, we are helping employers quite a bit with policies in that area. So if that's something you need, if you need a policy to help you sort of communicate to employees about those rights and help your managers manage it, we can help with that. Now, as you're thinking about are you going to terminate employees? Are you going to furlough employees, potentially reduce hours? Each one of those decisions has consequences, legal consequences and financial consequences. And hopefully it was clear from some of our other presentations that you can't make that decision in a vacuum. If you're going to decide to terminate employees or furlough them or reduce their hours, you have to think about what are the unemployment consequences. What are the CARES Act consequences? Are you going to be applying for SBA loans or other government relief that might be impacted by the decisions you make in this area? So this is really something you have to, have a real comprehensive plan about. And I realize that's really difficult when you're making these decisions, in very short order. But when you're deciding what to do with employees, I think there's kind of three major buckets. You might be terminating employees, which is, letting them go permanently. They may come back at some point, but at least for now, it's permanent. You might be furloughing employees, which just means they're still employed by you, but they're not going to be put on the schedule. They're not going to have work for some period of time. And you could also just be reducing their hours. Now, all three of those categories of employees are potentially able to apply for unemployment benefits, as Mark explained. Definitely if they're terminated, if they're furloughed, even reduced hours, if it's enough, could make somebody qualify for unemployment. So that's a piece you want to keep in mind. It's also really important for you to keep in mind that you need to understand the benefits that the employees have and how each of those decisions might impact their benefits. So if there's one thing I want you to walk away with today from this portion of the presentation, is go talk to your providers, your carriers, about how they are going to handle those sort of things. So for example, if you terminate an employee, obviously you give them a COBRA notice. They don't get health benefits. Usually they get it for the rest of the 30 days of that month, but they don't get it after that. But you want to check with your health carrier about what those requirements are. If employees are furloughed, they're taken off work, but they're not terminated, but they don't have the hours. Normally, under a healthcare policy, they wouldn't qualify for benefits because they usually have to work some minimum number of hours per month. Oftentimes it's 30. So you need to check with your health carrier about what that is. A lot of health carriers, though, right now are relaxing those requirements. So you can often check with your carrier and get a letter from them that says, no, we will not take people off healthcare benefits if they're, if they're just furloughed for a period of time and they don't meet the hours requirements. So, check with them right away and find out what those requirements are. You also want to check with your, if you have flex accounts, if you have health savings accounts, any other benefits, check with those providers, those carriers right away and find out what the implications would be if you make one of these decisions. If you terminate, if you furlough, if you reduce hours, what's that going to potentially do to your benefits profile? You really need to understand that before you make one of these decisions. So that's really mostly what I wanted to talk about in that area. In terms of healthcare benefits, if you are able to get an agreement from your healthcare carrier that they won't take people off the plan if they're furloughed, you still have to figure out how people are going to pay their premiums if you don't cover 100% of it. And you could decide that as well. Are you going to pay 100% of it? Do you want to do something different than you normally do? For example, some employers right now are deciding, yes, we're going to take people off of shifts. We don't have work for them. They're going to be furloughed, but the least we can do is pay for their healthcare premiums for a period of time. So if that's something you want to do, you need to talk to your health carrier about how you do that, what the expense is going to be, and figure out how you're going to communicate that to your employees. But if you're going to furlough them and not pay all of it, you've got to figure out how you're going to get the employee's portion of their premiums. You could recoup it all later when they come back to work. You could require them to prepay it out of their last check before they go off. You could require them to pay as they go. These are all potential options, but again, it's something you have to talk to your employees about. You're going to have to figure out if it's something you're allowed to do, and what your healthcare carrier would require. So now we can go to the next slide and talk a little bit about the WARN Act. Like I said, this probably doesn't apply to most of you. In normal times, you have to provide 60 days written notice if you're going to do a layoff, and you're a large company, if it's going to be a large reduction. There are some exceptions. So a large employer is basically an employer with 100 or more full-time employees, or could be 100 or more employees with part-time employees included in that if it reaches a certain hours requirement. Now, if you're potentially close to this 100 employee count, it can be a little tricky to figure it out, and you probably want to talk to counsel about that. It only applies to large reductions. Under the Act, it applies to what's called a plant closing or a mass layoff. And a plant closing is any kind of permanent or temporary shutdown of any type of business if it includes at least 50 employees who are either, and it doesn't necessarily have to be the entire company. It could be a single employment site. It could be one operating unit, one facility. So again, this is a little bit tricky sometimes to figure out. But the good news for most employers is there's a lot of exceptions that are probably going to apply in this unique time. So a mass layoff is at least 500 employees at a single site, or it could be as low as 50 employees if it's at least 1/3 of your workforce. That would be a mass layoff. An employment loss is a termination, which we talked about, just really letting someone go, but it could also be a layoff or a furlough if it ends up being more than 6 months. Now, hopefully this is not going to be more than 6 months, but it's a little hard to know right now. It could also be a reduction of hours of your employees if that's at least 50% over a 6-month period. The WARN Act does sort of have a look back and a look forward period that makes sure that you're basically counting all of the employees who are subject to an employment loss over a period of time. Now, if it is triggered, you do have to give 60 days written notice. It has to be given to a number of, to employees, to government officials. In normal times, this is a way for governments to sort of help plan for a company in the community closing down or laying a lot of people off. I think right now, if you gave a notice like this to a government official, they wouldn't even know what to do with it. They would be getting so many of those, they would be overwhelmed. But if the WARN Act does apply to you and you don't give the notice, you could be liable for back pay, benefits, attorney's fees for that entire 60-day period if you don't give any of the notice. So it's pretty big penalty. There's also a civil penalty. Now, the good news is, on the next slide, there are a lot of arguments right now that the WARN Act may not apply if you're shutting down, because employers don't really have a lot of choice. If you're closed down because basically there's a government notice that you have to shut down, your type of business has to shut down, and you have to do it tomorrow, then obviously you cannot give 60 days notice. But regardless of whether the WARN Act applies to you or not, is one other thing that I'm really telling employers right now is it's critical that you update employee contact information. You're going to probably have to be making decisions on really short notice. So you want to make sure you have current email, text numbers, phone numbers, whatever you need so that you can communicate with employees really quickly if there's a change in how your workforce is going to operate. The 60-day notice period is reduced or eliminated if there's a faltering company, unforeseeable business circumstances, or a natural disaster. Now, right now, those are not usually something, my 25 years of practice, I've rarely seen those come into play. But right now, a lot of businesses are qualifying for an exception to the WARN Act because of unforeseeable business circumstances, or this may be viewed as a natural disaster. So if you have to shut down in less than 60 days, there's a really good chance that the WARN Act probably will not apply. Now, that being said, next slide, you're going to be required to give as much notice as you possibly can if it does apply to you. And even if it doesn't apply to you, you obviously ought to give your employees as much notice as you can. So if you're expecting that you're going to have to make a decision like this, as soon as the decision is made and you're able to work with your counsel to prepare a letter to communicate to the client, to your employees, what the action is, you should get that to them as quickly as possible. One of the main reasons for that is so employees can start applying for unemployment as quickly as they can. This next slide just talks about some of the reasons you might qualify for the business exception. An initial layoff that is short but goes beyond 6 months, just because of circumstances that we might not be able to foresee right now, could possibly also be exempted. Now, I talked a little bit about natural disasters. Normally, those are floods, earthquakes, drought, storms. I feel like we've experienced all of those recently, but we've never really had a pandemic, but there's a good argument that that would qualify. Now, if you look at my very last point on this slide, all of these decisions that you make about termination, furloughs, what you're going to do, if you do it with an attorney, there's a lot of attorney-client privilege that that can attach to those decisions, and which means that those can be kept confidential and wouldn't have to be given to the opposing side if there's a lawsuit down the road over these decisions. So that can be one of the benefits of working with counsel on these issues. Now, even if there's not, if the WARN Act doesn't apply to you, there could be a state, what we call mini WARN statute that applies. California has one, for example, that kicks in at 75 employees instead of 100. Now, Utah does not have any sort of mini WARN statute or any other statute that applies to layoffs or furloughs. Now, that being said, in these times, legislatures are changing the law all the time, and if the Utah legislature reconvenes in an emergency session, they might pass some new laws. So this could change. You need to always stay, up to speed with that. Now, even if the WARN Act doesn't apply, no matter what size company you are, you have to make sure that any decisions you're making about who stays on and who's let go or who's furloughed is not discriminatory, that you're documenting the process in determining who is included in the furlough. You're using objective criteria. This is where you could really get a lawsuit down the road if you're not careful about how you do it. Is someone saying that this had more impact on women or more impact on people who are disabled, something like that.
Christina, we need to wrap it up in about 1 minute.
Okay. So there's just a couple more slides about some other concepts you probably ought to keep in mind if you're doing any sort of termination or furlough. But like I mentioned at the beginning, really the most critical thing, I think, is for you to immediately talk to your benefits providers about what the requirements they have in place for those kind of decisions, and make sure that you're communicating correct information to your employees about that. Thank you.
Okay, thank you all very much. I know we're bumping up against the top of the hour here, but we do want to leave a few moments for some questions. Mark, are there questions that have come into you that you would like to assign to the panelist or address personally?
Yes, and is the audio still sketchy, or can you hear me?
Just talk as loud as possible.
Okay. So I do have one question here, and that is to the direct that to Susan, and it relates to the paid sick leave requirements under the Families First Act, and basically it's how do employers deal with these? I mean, wait till they get a request, or should they issue any or amend any policies about sick leave, paid leave, FMLA leave type of time? And should they have policies in place, or should they just wait till they get the question?
Thanks, Mark. You should not wait until you get the question. This is something, it is changing every day. The DOL yesterday dropped hundreds of pages of regs. The Treasury is dropping regs. And, you know, the fact sheets that each of these institutions is putting out, like, keeps getting added to every few days. However, that being said, you really, particularly because with FMLA, and this is a brand new statutory requirement for sick leave as well. Some of you may not have FMLA policies. I would recommend getting a policy in place. There's some other considerations going forward as well about if you have a very generous sick leave policy, how that can be amended now, that sort of thing, to take into accommodation that employees are getting 2 additional weeks of sick leave under this federal act. We have put together a set of policies that are available that can be tailored to your company and your business and particular needs, and integrated with your existing policies or where there is no policies. But we do recommend doing that now, in particular because a lot of this is very confusing. So.
Thank you. And that's the only question at the moment. And given the time constraints, that's probably a good place to leave off.
Great, thank you, Mark, and thanks, Susan. Hey, before I turn the time back over to our host, I'd like to extend a huge thanks to our panel for the extraordinary amount of time that they've put into staying on top of all of the COVID-19 legal issues that are associated with the pandemic. So thanks again for your time. Also, I'd like to extend a thanks to FOBA again for allowing us to be a part of their webinar series. And then lastly, I'd like to thank all of you who attended today's webinar. And on behalf of Parsons, Behle, and Latimer, we wish you, your families, and all of your colleagues the very best. Please stay healthy. Sean, I'll turn it over to you.
Great. Thanks, Jason, and to the panel. That was, I know, a lot of information, and yet so helpful for us to understand and to know some of the nuances that are there. And I know there is a lot more information that will continue to come. So thank you so much for all of your efforts and your time for doing that, you know, especially at such a pivotal moment in time as we, you know, transition here. So want to again remind everyone there is another event next week, same time, Thursday, April 9th at 10 a.m. We will send that link out. Also, we will also be providing a recording of the panel and the video for today. So if you have any questions you want to go back and review, you're welcome to do that. I know Jason would be happy to facilitate any questions that you have for the panel and the attorneys there. So again, want to thank everybody for attending and for your participation and for you know, coming together to learn this information. We are now going to have an optional breakout. We did this last time. We had a lot of good feedback. And so we'll basically be putting people into different groups, and you can kind of discuss some of this content or anything related to struggles you're having with COVID-19. If you have other commitments, it's no problem. This is optional. But again, I want to thank everybody for attending, and hopefully we'll see you again next week. Thanks.
Thank you, Sean.
Thank you.